Are you done shaking your head? You don't have to agree with a darn thing I'm saying. But I'll be darned if you're going to sit here and disrespect me in my courtroom like you did them in the hallway. That's not going to happen, ever. Court does call the case of the people versus Debian.
Good afternoon again, Your Honor. People.
Good afternoon, Your Honor. Justin Zane appearing on behalf of Davion Morgan City.
Yep, I'm Morgan.
Okay. All right. Where are we on this?
Your Honor, I've had an opportunity to show defense counsel the video as well as audio that I referenced previously to the court's my understanding that we are having a hearing on this bond violation. I do have the witness present and ready to begin whenever the court wants.
That's correct. We're ready to proceed.
All right. Go ahead. I'm ready.
Well, Stephanie Sings.
And please come forward and be sworn. Main court.
Good afternoon, Stephanie. How are you doing? Stephanie, how are you involved with this case?
I am the guardian for Ms. Joyce Glover.
And that's the named individual on the complaint, is that correct? Where were you this morning at about 10:50 a.m.?
Staying outside of the courtroom.
Where outside the courtroom?
Go out these doors. I was on the bench on the left.
Was anyone else out there with you?
Yes, one of the other witnesses, her first name is Diane.
Where was Diane seated?
She was sitting, and I'm facing out the window. She was on my right side.
Was anyone else in the hallway with you? Or not with you, but was there anyone else in the hallway at that time? Who?
The suspect was sitting on the bench right of the doors with some other people that I know that they are.
When you say the suspect, who are you referring to?
Beyond Morgan. I'm Morgan.
Can you please point to that individual and identify them by an article of clothing that they're wearing?
Yeah, the white shirt. I think it's got a nice. No, I can't see it.
All right.
The record may reflect this witness has identified the defendant.
Record shall so reflect without objection.
Who was the defendant?
Making verbal comments in my direction.
What sort of verbal comments?
Started off, I believe it was a skinny ass cracker, and then went on to a number of other things, making comments about a bitch and a hoe, and that I wasn't going to get away with this. The gist of it was that she was going to keep stalling it, taking it to trial, taking it to trial, and taking it to trial. It just kept going for about probably close to 2 minutes.
Did you record any of that interaction? And did you have an opportunity to listen to that recording prior to taking the stand? Would you recognize it if you heard it again? Or if I can plug in and just play a second just for foundational purposes. Plug this in correctly.
And just so I'm clear, you were recording this?
I started to record it after probably about 30 seconds of
Okay.
I realized I wasn't actually looking in the direction of Ms. Morgan or Devion, but I could see her turning back and looking at us, so I started to record it at that time.
Gotcha.
And what were you recording on, ma'am?
On my cell phone.
And I'm going to play again just the first second here of Morgan _ recording just for foundational purposes. Do I have, that might help. So I just played about the first 4 seconds. Ma'am, do you recognize that audio?
If you could play a little bit more.
I'll turn it up a little because it's a little bit quiet. You recognize that audio? Is that the audio that you recorded today? And having listened to this, is this a fair and accurate copy of the recording that you made? Your Honor, for the purpose of the bond violation hearing, I move to admit what's been marked as People's Proposed Exhibit 1.
Any objection or voir dire?
Oh, yeah.
Exhibit 1's admitted.
Permission to publish, Your Honor?
Yes, sir.
Ma'am, other than that audio recording, have you had an opportunity to view any video recording from this incident? And can I put up People's Proposed Exhibit 2 for foundational purposes?
Yes.
All right, and pausing just on the start here. Ma'am, do you recognize this video? What is it?
It's the hallway outside of the courtroom.
All right. And how do you recognize this video? Do you see yourself in it anywhere?
To the right, the far right, in the white jacket.
I don't know if my mouse does come up. Is this you right here?
That is, yes, correct.
All right. And have you watched this video before? And is this a fair and accurate reflection of what happened in the hallway? Your Honor, I move to admit with marks people proposed exhibit 2 for the purpose of the bond violation hearings.
Any objection of what here?
Permission to publish?
Yes.
And just for the record, this is about a 5-minute, 9-second long video. There is no audio on this one. I am pausing at the 30-second mark. Ma'am, do you see the defendant anywhere in the video at this point?
Yes, she's sitting on the bench to the left of the door to the courtroom.
I'm hovering my mouse over an individual. Is this the individual you're referring to? I'm going to continue from the 30-second mark. Gonna pause it at 4 minutes, 30 seconds. The last 30-ish seconds, that important, but certainly if the court wants to play it, I can.
Pardon?
I'm gonna just pause it here.
That's fine. Whatever.
Can we take me off, please? Thank you. Prior to the defendant making any comments to you, had you said anything to the defendant? Did you ever say anything to the defendant today? How did it make you feel when the defendant was saying these things to you?
Intimidated. I think that she was trying to intimidate me.
And just to clarify, ma'am, what is your understanding of why you were subpoenaed to testify or subpoenaed to be here today?
Because of identity theft, and I'm not sure of the exact charges, but what I believe were financial exploitation issues for a elderly, vulnerable adult.
And were you prepared to be a witness in that case? And were you prepared to testify today? If I can have one moment, please, Your Honor. Nothing else at this time. Thank you.
Cross-examination.
Just a few questions, ma'am. We just watched that interaction on, I believe, exhibit B or 2. Appeared to be roughly 5 minutes. Anytime during that interaction, did Miss Morgan say your name or otherwise address you personally?
I'm also known as a cranky, skanky ass cracker.
I'd ask the court to strike that from the record. I asked if she'd mentioned.
I think she answered your question.
At any point in time, did you observe Miss Morgan leave the bench that she was on and come towards your bench? And at any point in time, did you see Miss Morgan gesture either with her hands or otherwise towards you in any way? Okay, and what exactly did she do in order to gesture towards you?
So you can see on the video, I did not turn to look at this. Can you clarify, Miss Morgan? Is that
Yeah.
Okay, Miss Morgan. I did not turn and look at Miss Morgan this way, but periodically I looked toward the window and I could see her gesturing toward, turning around and gesturing and moving.
Okay.
Right.
So towards this direction, but could you confirm whether it was towards you or down the hallway?
It was toward Diane and me.
Okay. Were you aware where her counsel was, myself, where I was positioned at this time during that 5-minute interaction?
At the courtroom.
Okay. And at any point in time, did you see me head down that hallway?
I believe at one point, yes.
Okay. And so when you saw Miss Morgan gesture towards that way, how were you able to discern that she was pointing at you versus talking about her counsel?
I'll see you down the hallway.
Okay. And it's my understanding that there were a couple other women on her bench. Is that correct? And would you agree with me that at some point in time she was conversing with those other women? And it sounds like you were able to hear some of what they were talking about. Is that fair to say?
Yeah, women. I mean, I'm assuming they were women based on the video, but I could not hear what they were saying.
Understood, but you could hear what Miss Morgan was saying. And so did you observe Miss Morgan interacting or otherwise conversing with these women? Okay. Were you able to hear Miss Morgan addressing any statements or making any statements towards those women? Okay. When you heard the statements that Miss Morgan were making, how would you know whether she was talking about her case to these women versus addressing them to you?
She was turning and facing me and turning her arm toward me.
And you were able to only observe that when you periodically looked at the window?
Tell that she was the way she was positioning, because turning around in the video that I'm looking down, but I could see the way she was turning around.
Okay, but when she was making the statements that you were able to hear and periodically see, could you confirm whether or not she was actually making those statements to the women that were on the bench with her?
Can I give you an example?
I'm just asking that.
If I turn and talk to this person over here, is there a way to know that I'm talking to you or to this person over here? So because she was turning and looking at me, I was just making the assumption based on the commentary and the threats about going after me.
Okay.
Trial and taking this to trial and threatening me to get an attorney, that the comments were being made to me.
Okay, so you were making the assumption that it was addressed to you because it was about this case.
Correct.
Okay. And do you know if Miss Morgan was ever instructed by the court or otherwise not to be on that bench out there?
I don't know if this witness would know the court's orders.
Were you aware of any court order that she wasn't allowed to sit in that area?
The objection is the lack of foundation for the question. Go ahead.
Okay. Did you ever hear anyone tell Miss Morgan that she's not allowed to sit there? Okay. And did you ever hear Miss Morgan address the other individual that was sitting next to you by name? And did you ever observe Miss Morgan get up from her bench and come and address that other individual? Okay. And outside of this interaction that was depicted on the video, is it your testimony today that Miss Morgan made any other statements directly to you? Okay, that's all I have.
Any redirect?
No, Your Honor, that's
Just one question. Was that Miss Plummer that was seated next to you?
No, the woman sitting next to me was Diane, who's next to Detective Quinn.
Gotcha.
She's one of the witnesses that was testified today.
Hold on just one second. Gotcha. Okay. All right.
nothing further, Your Honor.
All right. You may step down. Thank you, ma'am. Any additional witnesses?
No, Your Honor.
All right. Any witnesses for the defense?
No, Your Honor.
All right. Thank you. Argument.
Your Honor, I would ask that the court find the defendant violated the conditions of her bond, namely the no contact, or I believe she was ordered not to have contact with Stephanie Sings. I believe she was also ordered not to have any new criminal conduct. I'm not sure if it was ordered. I believe at a range on the pretrial release order, but typically there's condition not to have any assault, intimidating, threatening, or harassing behavior. If that is an order, I believe it would be a violation of that order as well. The court saw the video and heard the recording of the defendant was making some pretty serious derogatory remarks about witnesses in this case, calling them bitches and hoes. The court saw the video, could see that the defendant was apparently looking at and making a conversation directly to these witnesses while they were in the hallway together. Certainly, whenever anyone comes to the court, I believe that there's an expectation that they be treated with dignity and respect, and that we should not be afraid to come to court or be harassed while at court. And I think that what the defendant has done is a clear violation of her bond. I would again ask the court find that she has violated her bond for both bond.
Your Honor, we would certainly ask the court to consider continuing her bond. While I may take issue with the choice words that were played within that video, and certainly would agree that there should be a level of integrity and dignity with confines of this courthouse, I don't believe that it is a violation of her bond conditions to use those choice. Heard testimony today that would indicate that Miss Morgan intentionally directed those statements towards the witnesses as opposed to expressing her frustration.
Where then was she looking? Recorded.
Hold on. I think that the video speaks for itself, that she definitely turned her head at some point in time towards that direction. But I think when you review the video in totality, she's positioned this way to talk to the two women next to her, talking about her case, expressing the frustrations that she has about the case. And while I think you heard that there was an assumption that those statements were directed towards these other individuals, and at no point in time did I see in the video my clients stand up or otherwise point at these two people or otherwise use their name to mention them. I mean, we know who the witnesses are.
When she put her hand out like this, what was that for?
Your Honor, when she puts out her hand like this, I'm assuming what she's saying is talking about the case, the whether it's me as her attorney, whether it's the judge, whether it's the witnesses, speaking about her case. She's saying that she disagrees with where the case is procedurally and how it's going. I think that if she had the intention of intimidating these witnesses, at any point in time, she could have stood up and said something to them, turned around and pointed at them, used their names as she knew who the witnesses were. There was no intentional direction towards these two witnesses to try to intimidate them not to speak when we already knew that they were here to speak. And so if that was going to happen, Your Honor, it would have happened the last time that they were here in order to testify at the preliminary exam. She's shown up at every single hearing. These witnesses have been there before. Before that 5-minute window, after that 5-minute window, there was clearly no, nothing that would show or otherwise indicate that she's trying to intimidate them. They were here at the last hearing. Obviously, she knew that they would be here again. And at that point in time, without, getting into it, but kind of getting into it, is that we had already decided that we're waiving the exam and moving forward. So any effort to intimidate and otherwise encourage the witness not to testify would have been moot, because we were waiving the exam and moving forward with the case up in circuit court. What we decided to do at that point in time remains to be seen. But for today's purposes, there was no effort to intimidate those witnesses, because we had already made the decision to move forward and there was not going to be an exam today.
So intimidation, if it were occurring, would only be for this limited date?
No, but I think when you're looking at the totality of the circumstances for today to determine from the video, from the recording, from the testimony you heard.
Counsel, you going to tell me that when I look at that video and that aerial view, that your client is facing in the direction of her sinks, and the words that are being spewed from her mouth aren't directed at her?
Well, I wasn't there myself, Your Honor. I can go off.
Counsel, don't play word games with me. You heard the recording.
Yes.
You see the posture of your client as she's sitting on the bench. And are you arguing before me that that was not intended at the two witnesses, inclusive of Ms. Sings, as they're sitting there?
No, I'm not trying to insult the intelligence of the court. You saw what I saw.
Thank you.
Speak for itself. And so I'm not going to sit up here and say that. What I would indicate is that I think that my client's expressing a general frustration about her case, as opposed to utilizing those words to try to intimidate them not to testify. That's what I would indicate to the court. What is? I just want to explain.
Briefly, Your Honor, if it were just the language and the derogatory terms, I think maybe that argument might hold weight, but I think that consider that the defendant also stated after this is over, I'm going to get lawyers and come after you, or something to that effect. I don't remember the exact language. I think that clearly shows.
Yeah, hold on a second. Tom, you've interrupted Mr. No, do not do it again. Otherwise, I don't have to deal with it. Oh. Go ahead, Mr. Cook.
Thank you, Your Honor. I believe that language clearly shows that intent, that this is directed at these witnesses, and it clearly, as the court heard, had the effect of making these witnesses feel afraid. I would again ask the court revoke bond.
With respect to that statement, my clients previously indicated to me when we listened to the recording and talked about that she's telling those two girls on the bench next to her that that's what she intends to do. And so while the court can certainly interpret it that those statements are directed towards them as a threat, she's saying she made those assertions towards the people next to her that that's what she wants to do as a matter of recourse for this case.
All right. Court has heard the audio. The court has viewed the video in this case. I realize sometimes lawyers are put into circumstances where they certainly have to argue on behalf of their client, and I don't fault them for that. That's what lawyers do, inclusive of myself when I was a lawyer. And you can only hold. But when I listen to that recording, then I look at the defendant's posture, the way she's looking. There's a period of time where she's looking either straight ahead or toward the people that are sitting on the bench with her, which would have been to her right. But then intentionally is turning and looking in the direction of Miss Sinks and the other woman on the bench. That's when those statements are being made. You know what?
Wow. This became much bigger than just a bond violation. The judge clearly viewed the defendant's courtroom behavior as a continuation of the exact same disrespectful conduct seen in the hallway. Judges place enormous importance on courtroom decorum because they see themselves as protectors of the judicial process, especially witnesses and victims coming forward to testify. And from the judge's perspective, the defendant wasn't merely disagreeing. She was openly showing defiance while the court was explaining its findings. That line, "I'll be darned if you're going to disrespect me in my courtroom," tells you the judge believes this behavior pattern is escalating, not improving. At this point, bond revocation is looking almost inevitable. The court now sees both the hallway comments and the in-court attitude as evidence the defendant cannot follow conditions while out on release.
You want to keep shaking your head? I'll wait. Because I got all day. Are you done shaking your head? You don't have to agree with a darn thing I'm saying. But I'll be darned if you're going to sit here and disrespect me in my courtroom like you did them in the hallway. That's not going to happen, ever. Am I under? But it was very clear that she's looking in the direction of instincts. Well, and making those, some of the parts of it just sort of god-awful statements with an attempt clearly in this court's mind to intimidate Ms. Sinks and the other witness and to testify so that we're real clear in terms of her bond conditions. She is not to have any direct or indirect contact with the following persons, and that includes Stephanie Sinks. That is condition S on the bond form. That is just clear. She's not to have contact. That is a very big, long hallway. The courtroom is a reasonably good size. The defendant could have come and sat in the courtroom at any given point in time. She knew who Miss Sinks was. She knew exactly who she was talking to in the hallway. She could have come, Miss Sinks wouldn't move. She could have come and sat in here. And that's her obligation, is to avoid contact with Miss Sinks either directly or indirectly. She purposely did that. I think she did it. You know, when people come to court, whether it be a defendant, whether it be a victim in a case, whether it be a witness, they are not to be intimidated into doing whatever they're doing, whatever stage it's at. If Miss Sinks, just to address counsel's point, that while the decision may have been made to proceed in a particular direction, it isn't the issue of whether or not there was going to be testimony and whether or not it was the defendant's intent to stop Miss Sinks from testifying. That's not the issue. She's not to have any contact, direct or indirect, with Miss Sinks. If Miss Sinks decided to just come down to this courthouse and just sit in that hallway, I don't know why she would, but that's fine. If she just wanted to come down and sit in the hallway, this defendant has to remain out of contact with her. She didn't do that. In fact, she was attempting to try to, in my opinion, in looking at that and listening to the recording, she was attempting to try to engage Miss Sinks, to say those things, to intimidate Miss Sinks, not only for today, but I think in terms of further proceedings, because this case isn't over. That's the defendant's obligation. Miss Sinks is not under the jurisdiction of this court to do anything. This defendant is. The court, after listening and seeing all of that, having heard argument, is going to find that the defendant was involved in the yelling and inappropriate phrasing at protected parties to the case in the 14A1 hallway, and that the court does believe was an attempt to intimidate the witnesses. This behavior, not tolerated today. It will never be tolerated in this courthouse. And so that we won't have a return of this at all, defendant's bond is hereby ordered revoked. Defendant is remanded to the Washtenaw County Jail.
Two really quick matters. I apologize. I neglected to mention earlier, I would also ask the no contact order include the other witnesses that were present today that were set to testify. I can provide that court now, or I can provide that in writing at a later date and time if the court would prefer.
If you could somehow or another get those other names on an order for the court to sign, I will add those individuals.
And then may I approach to sign the information I failed to do today?
Yes, you may. Jay?
That's it.
Yeah. That's a short day. 14A.
In the end, the judge ruled that the defendant knowingly violated her bond conditions by indirectly contacting and intimidating protected witnesses inside the courthouse hallway. The court emphasized that no contact orders don't just prohibit physical confrontation. They also prohibit behavior meant to harass, pressure, or intimidate witnesses connected to the case. Despite the defense arguing the comments were merely expressions of frustration, the judge focused on the defendant's body language, repeated turns toward the witnesses, threatening remarks, and overall conduct both in the hallway and inside the courtroom itself. The result was immediate and severe. Bond revoked, remanded to jail, and additional no-contact protections expanded to other witnesses involved in the case. This hearing is a powerful reminder that judges take witness intimidation allegations incredibly seriously, especially when they happen inside the courthouse itself. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.